Well, welcome back to your long-range plan. My name is John Kennan, and with me is co-host Paul Tierney. We are both attorneys, elder law attorneys with offices here in Sandwich and in Quincy. You'll see at the conclusion of the program the credits for more specific information. Paul, so how is it today? How's everything going?
Very good. How about yourself?
Good. We're going to do something a little different. You and I had a brief discussion earlier, and I think it's wise that we talk about veterans' benefits and what that means, eligibility. I've got a few little questions here to get it going. You know, what is the so-called aid and attendance pension? Or do you want to kind of start from the very beginning on what are these benefits and who's eligible, and we'll take it from there.
Well, yeah, I mean, doing work for elders, we run into this from time to time, when it's appropriate, what it's all about, and basically if somebody is a veteran or has been married to a veteran, and what we mean by veteran is somebody who served at least one day during wartime. Now, they have specifics on that, but it seems, in my experience, most people meet the criteria if they've been in the service, if they've served during World War II, the Korean War, you know, Vietnam War, or any of the Gulf and Bosnian wars. You're considered eligible. It's a benefit. It's not for everybody, but where we run into it servicing elders, when elders need help with their activities of daily living, they could be eligible for this benefit through the veterans, you know, through the VA, and that's what you had mentioned earlier, this aid and attendance. It's part of the pension benefits that you're entitled to, okay, but you'd have to meet certain criteria to be eligible for that.
And what are those criteria?
Well, first of all, there has to be a medical necessity. There has to be medical expenses that are more than the elder's income. And there's also an asset test, too. So if you meet the criteria of your expenses being more than your income on a monthly basis, and if you're under the asset amount, then you could be eligible for this aid and attendance.
Okay, let's talk about just the nuts and bolts of this subject matter. All the questions that are going to come up, I'm sure, for the viewers listening, is, you know, what are the thresholds? I mean, is this akin or similar to when we plan a Medicaid plan? Does the veteran have a certain amount of money that he or she is allowed to have in his or her name? The spouse, I mean, how is all this going to work with the funding? You talk about asset and, you know, asset and liability, you know, formulas. So how does all this work? What are we supposed to know?
Well, first of all, this aid and attendance, it's not to protect your assets or to build up a beneficiary's estate. Okay, so you need to be aware of that. That's not the intention of it. It's to help the elders out. So we run into it for planning purposes. Run into it kind of all the time. And it's not for everybody. It kind of depends on the facts and circumstances. Could be where an elder is at home, okay, but needs more assistance. Okay, it could be that they're having family members help out. Okay, and again, based on what's going on, that's when we step in and we take a look and we can do some planning and quickly determine whether the elder is eligible based on their financials, what's going on income-wise, what's going on expense-wise for servicing the elder at home, or a lot of times we see this if elders are medically determined that they can't be home anymore and they need to go to an assisted living facility. I mean, those facilities are private pay, and usually the pay at an assisted living facility is on the low end $3,500 and up the high end, you know, $8,000 or $9,000 per month. So most elders don't have the monthly income to be able to sustain that or to pay that type of an expense. So these are elders that would, you know, if the elder himself or herself is a veteran or had been married to a veteran, then they could be eligible for this aid and attendance.
Okay, got a few things I jotted down here. Just, again, questions that typically, well, will come up. How long would it take procedurally to process an application? Does a veteran or veteran need someone like us to assist with the paperwork? Can he or she handle this on their own? And I believe I know what your answer is going to be, but I have to ask the question anyhow for the viewers.
Mm-hmm. Well, first of all, as an attorney, you have to be a VA accredited attorney to be able to help, in this area.
Mm-hmm.
Yeah, elders don't have to use us for assistance. They can apply on their own. I mean, my experience has been, you're juggling all sorts of laws. Most elders aren't immediately eligible, so they may have to do some planning to become eligible.
Mm-hmm.
And that's where we come into play. We like to take a look at an elder's situation first. Not to have the elder come in and say, hey, I have the application, let's apply. No. Let's find out what the elder's financial situation is first, and then we can plan. We can, if somebody's eligible immediately, and if there's no planning that needs to be done, then wonderful. That can be done by the elder. It can be done by us, the filing of the claim. It can be done by a veteran service organization. Those are set up in just about every town, and those people will help elders, file their application. But they typically don't help with the planning.
Mm-hmm.
And like I said, my experience has been many times elders or their widows, with a little bit of planning, can become eligible, but they may not be immediately eligible.
Mm-hmm. So in gathering the information, or in the process of assisting someone with these benefits, what kind of documents does the veteran have to produce? And what are we looking for?
Well, first of all, we need the discharge paperwork.
Mm-hmm.
Okay, that's very, very important.
Mm-hmm.
Because you need that as part of the application.
Mm-hmm.
And you can order that from the VA if you don't have it already.
Mm-hmm.
So many times we ask the applicants to get at least two,
Mm-hmm.
The original and plus another one from the VA, because we need to submit an original, with an application for aid and attendance benefits.
Mm-hmm. And in addition to the discharge papers, what other relevant documents does a potential beneficiary have to provide us?
Well, again, you have to prove that you're financially
Mm-hmm.
eligible. So you
Mm-hmm.
need to be able to prove your income. You need to be able to prove your assets. So
Mm-hmm.
that means we need current bank statements,
Mm.
copies of those, current IRA statements. Your latest financial information, we need that. We also need, some information from the doctor. The doctor stating that you can't meet certain activities of daily living, and therefore you need to be in an assisted living facility, or that there's a risk of fall and that you need assistance at home. So it's documentation like that that's part of the information that's needed with the application. But again, I always stress it's always best to plan. Let's find out what's going on first. Mm-hmm. Let's figure out the financial situation of the elders, and just what are the doctors recommending, and then we can tell the elders if it's appropriate to even apply for a VA benefit like aid and attendance. They have other benefits also, but that's one that we run into all the time, is the aid and attendance, because of the planning that we do.
Mm-hmm. So what we're talking about is driven by assets and liabilities. There are certain thresholds that the beneficiary can't exceed in terms of financials, what they have for net worth, et cetera.
Mm-hmm.
Geez, I hate to even ask you this question, but does that whole look-back period come into play here too? If someone's trying to maybe give some money away, move things around, as they say, so that they can qualify.
Mm-hmm. Good question. First of all, the aid and attendance, there is no look-back period, at least as of yet.
Okay.
They're talking about maybe instituting one, but as of now, there is no look-back period.
Good.
But whenever we're doing VA planning or any this type of elder law planning, you also need to take into consideration, well, what if the worst case scenario happens and the elder at some point has to go to a nursing home? We always have to keep that in the back of our mind because if you're transferring assets or you're setting up some type of a trust, there needs to be in the back of your mind the possibility of maybe someday having to switch and become Medicaid eligible. Now, when we talk about Medicaid eligibility, as we have on prior shows, that's where there's a 5-year look back whenever you apply for benefits. So if any assets have been given away within a 5-year period of time for Medicaid purposes, that's going to become an issue and possibly a problem. So that if we're doing VA type of benefit planning, we also need to be in the back of our mind saying, all right, well, what about if the elder has to switch over and apply for Medicaid benefits? So it's kind of all part and parcel of, you know, looking out for what's best for the elder, knowing that, okay, this aid and attendance as a VA benefit is another kind of tool in our arsenal of what we're trying to do to benefit elders given their situation.
I have another question. Really important, I think. What if the applicant has designated a person, his or her attorney in fact, by virtue of power of attorney? How does that come into play with the VA?
Interesting. The VA does not recognize a durable power of attorney. Okay, so they want the elder himself or herself to sign any application for VA benefits. And if the elder absolutely cannot sign, well then you need to apply for appointment of a fiduciary through the VA. And then that person can sign on behalf of the elder. So in these situations, you're right, the power of attorney that's good for everything else that we may need to help out the elder for financial and legal purposes is of no help with applying for VA benefits. The veterans have their own way of dealing with that, and that's their own process to appoint a fiduciary to be acting on the VA beneficiary's behalf. And it's interesting because in every state we have guardianship laws or conservatorship laws, and even those aren't recognized by the VA. They have their own process for that.
Really intriguing when you think that the powers of attorney are so powerful, and we constantly communicate to our clients and be very careful as to who you choose to be your attorney in fact, because you can deplete bank accounts, deed properties away, et cetera, yet the Veterans Affairs folks won't recognize such an important and powerful document. So I think this is really important to know, or to jot down, that the VA does not recognize the typical durable power of attorney if you're contemplating starting a process or this procedure.
Well, not that I'd recommend not getting a power of attorney in place. Absolutely. I think that's a no-brainer document. Everybody should get one. It's just that when you're dealing with the VA, it's a different process. They have their own forms and procedures, and that's why you need an expert, you know, an accredited VA attorney to help you out, or to give you some advice before you even start the process.
So let me ask you this. This is purely an educational program. That's always our intent. And in the past, we've cited examples in the course of a roundtable discussion with other guests that you and I have had. And we've, from time to time, just kind of naturally just shared with the viewers our own experiences with our clients. And without mentioning names, as obviously and as usual, Is there any scenario, any kind of a example of something that you're presently working with now as it relates to this topic?
Yes, I have a few going on presently. I have one gentleman who's in a assisted living facility, and I want to say that's costing him like $4,200 or $4,500 per month in his income, his Social Security and pension and everything else that he collects on a monthly basis comes to about $2,200 a month.
Wow.
So obviously he doesn't have the monthly income to support the expenses, and based on that he could go through his savings pretty quickly. So this aid and attendance that he is eligible for based on his financial situation, and also based on the fact that he's a veteran, is entitled to it. That's going to help him stay in the community in an assisted living facility a lot longer period of time than he otherwise would be able to. So we had to do some planning with him. We had to shelter some of his assets, and I won't get into the details of exactly what we did in his particular situation, but also with the understanding that, hey, this assisted living solution may work for now, maybe for the next several years, but at some point he may need to go to more drastic measures. He may need to go to a nursing home if he can't make it in the assisted living facility, if he gets worse from a standpoint of being able to be cared there. So again, all these factors need to be taken into consideration when you're dealing with elders, when you're dealing with planning in this particular situation. But this fit him perfectly because with the additional income from the aid and attendance benefits from him being a veteran, that's going to help him stay in this assisted living facility, which the family feels is better than him being in a nursing home, and he really doesn't need a nursing home at this point, but it allows him to maintain that situation for an extended period of time that he otherwise would not be able to do if he wasn't able to get these benefits.
So let's just take that one step further. So what you're saying, or what you've identified as a supplemental benefit, more or less, to what the individual has, what he or she is paying out as a private pay matter. And as we move forward, as this person is private paying and there is a supplement, well, what happens when the private pay side of the equation is extinguished or close to being fully extinguished?
Well, again, the VA only pays out a certain amount per month. I mean, that's it. So it's to supplement the elder's particular situation. And if they have run out of funds on a private pay basis, then they're going to have to seek other solutions for their particular situation. So again, it's not a perfect solution. It's a help. It's another arrow in the quiver in our solutions for trying to help elders out. And I think another important thing to know too is this process takes time.
Okay.
If you have all of your information, if you had all your ducks in a row, so to speak, it still takes at the very least, 3 months to get approval.
Okay.
Typically a lot longer than that.
All right.
I mean, usually we see 6 to 9 months as a time frame to get approval.
Okay.
But once approved, then the elder will get a check on a monthly basis. And as a matter of fact, they'll get a retroactive check going back to the month after they applied. So if you apply at the end of November, then if you're eligible, then when they get around to approving you for the aid and attendance, the benefits will start December 1st.
Okay.
So again, that may take until March, April, May of the following year.
It'll begin in
but
December.
They will give you benefits going back to December 1st of the month after you applied. So if you apply at the end of the month, they'll if you're eligible, starting the next month, that's when you get the benefit.
Okay, so speaking of benefits, there are other benefits that veterans are entitled to. Does receiving other VA benefits jeopardize what we're talking about here today, does that foreclose any opportunity for this aid and attendance?
No, those would be a separate matter.
Okay.
Yep.
Okay. So I see you've written down an awful lot of notes for today's discussion. What else would you
Well,
like?
this wasn't for today's discussion. This is on a prior.
You've got an awful lot there, I could see. Any other highlights that you want to talk about?
Maybe just talk about some of the mistakes that
Okay.
people do make.
Okay.
Let me just go over some of those when applying for these type of benefits. Number one would be not using the name, the veteran's name, as it appears on the military discharge paperwork. Okay, that's something that the Veteran Affairs matches up. So if the name has been changed, or if the name is a little bit different, then you know what? You're just extending the period of time of getting the application processed. So that would be mistake number one, not using the exact name as is on the veteran's discharge paperwork. Another mistake would be listing the family member as the applicant. So you may have a family member, the power of attorney person, or the spouse, or the firstborn, or one of the kids helping the veteran out in the application process. Don't make the mistake of putting that person's name down as opposed to the applicant's or the veteran's name. If you do that, again, another mistake, another delay that's going to happen, and you're just going to extend the period of time of getting the application approved and processed. So that would be mistake number two, is listing the family member as the applicant. Another mistake would be listing the claimant's address instead of the point of contact person. Okay, so if the elder is kind of incapacitated, maybe the elder's living in the assisted living facility or not at home, who's going to get the elder's mail? If information requests come in from the VA and it goes to the elder and the elder doesn't tell you about it, then again, that's going to delay the process of getting the application approved. So you always want to have the point of contact person's address on here as opposed to the claimant's address.
Oh, okay.
So very, very important, because if they're looking for information, logically you got to get that information back to them so that they can process the application. So it's important that somebody be receiving mail so that they can jump on this and get going and be responsive in a timely manner. So that would be mistake number three, listing the claimant's address as opposed to the point of contact person's address. Another mistake would be listing the wrong number of prior marriages. So again, this is all important information that we need to have if we're processing an application. We need to know, how many times has the elder, has the applicant been married, and to whom? We need to disclose that. We need to put that on the form. So that's another mistake. If you're vague about that, or if you're just listing, the current spouse of the applicant, that's not enough. We need all prior marriages, all that information. So that would be mistake number 4, wrong number of prior marriages. Another mistake would be inaccurate representations of net worth and income. As an example, the house is an exempt asset, so it doesn't matter that the house is a expensive house somewhere, and that doesn't count as an asset.
Okay.
Okay, but if you're not listing, say, a bank account, okay, and you have interest income on your income tax return that shows that you have a bank account at Sovereign Bank and you didn't list a Sovereign Bank CD or a Sovereign Bank money market account, then that's going to be a problem. Okay, so you need to list accurately and represent, completely what the current situation is. So if we're putting together an application in late November and we're looking for a December 1st eligibility date, then we need a bank statement with accurate information as of November. That's what they're going to be looking for, not the prior November or back in the summertime. They're looking for current information. So you need to accurately represent that. So that would be mistake number 5, is inaccurate representations. Another mistake would be leaving questions blank. Don't leave questions blank on the application. Put down zeros. If they're asking for, you know, stocks and bonds and you don't have any, then 0 is the proper response, not just leaving it blank. So again, that would be you know, mistake number 6, leaving questions blank. Another mistake would be disclosing information that is not required. Okay, so if there's a trust that's set up, but your kids are the beneficiaries of that, hey, it might have been your money at one point, but now it's in a trust and the kids are the beneficiaries, well, you know what? That information does not need to be disclosed because you're not the beneficiary, and that's not relevant to the veteran's application. So again, that would be a mistake number 7, is disclosing information that's not required. And another, I think the last mistake would be not having the claimant sign the form. Okay, the claimant has to sign the form. You can help the claimant out. You can, you know, grab the claimant's hand and help them write it, but they're the ones that have to sign it. Okay, nobody, you can't sign as power of attorney for the person, as we discussed earlier.
Yep.
You have to have the claimant sign it. So that's a big mistake. Very, very important that the claimant himself or herself sign the form. So again, those are some of the things that you need to be aware of. Those are the mistakes that slow the process down. It's not a speedy process, but they have their job to do, and we can make their job easier by being complete, having all the necessary information, and not making any of the mistakes that I've just described here. That will facilitate the process. That will make the process go a heck of a lot more smoothly.
Well, thanks, Paul. That concludes our program for today. Once again, my name's John Kennan, and with me is Paul Tierney, and we look forward to seeing you next time. Take care.
Thank you.
Thanks, Paul.